When you listen to the tape, please listen, because Lewis Jr. is going to say, well, my dad told me about the gun. Now, he knew about the gun in New York. Both the boys knew about these firearms in New York. But my dad told me about the gun under the couch. And when the police officer confronts Lewis Sr. about that, he's kind of stunned. Well, I might have. I don't recall it. My boy is truthful. He didn't want to call his son a liar. That never would have happened. He didn't recall ever telling his son, hey, there's a gun under the couch. And he will tell you, ladies and gentlemen, I cannot imagine ever telling my child, hey, there's a gun under the couch, use it if you need it. He will say that never happened. Did he mention the gun? He's going to tell you, I might have. And he's going to tell you, my son is truthful. My son's a good kid. He's truthful. But he doesn't ever recall that. Ladies and gentlemen, you will hear, and please pay close attention, and please pay close attention to the state's evidence, because when you do, you will find that this man took reasonable steps to protect his children and to protect other children from this firearm. And that at the end of the day, regardless of the steps, this tragedy probably would have occurred no matter what. And that he is not guilty. Thank you.
So let's ask Dino Lombardi. First of all, is it a defense just to say the steps he took were reasonable?
You have to. I think his state of mind, Louis Mevic, his history of gun ownership and storage, his general approach to raising these children, the understandings of the circumstances of whether they would be at home, all of this I believe is relevant and will come out, because you're essentially trying to show that this was not something that rose to the level of a conscious disregard. Notably, she said it never occurred to him. Now, we may all argue, well, it should have occurred to him, but that's different than being aware of a real risk and just consciously disregarding it.
But doesn't it hurt him terribly that apparently he's going to testify, you know, I don't believe I ever told them that that weapon was under there, and as far as I know, they wouldn't even have known it was there.
Yes. I think that is something she dealt with probably as best as she could just then, and had to get it out in her opening statement. But his son, who he credits with being a truth-telling kid, and I think the jury will believe the kid is going to say, my dad told me the gun was under there. The defense theory is not that he informed his sons, the gun is under there, don't touch it, but that it was under there because it was hidden from his son. So that's a real problem, I think, for the defense.
And also the fact that he did not train them in gun safety. He said, don't touch the gun, and he said he thought they were totally obedient children. They didn't go on and train them and say, here's what you do to protect yourself.
Exactly. And so again, that's part and parcel of the defense theory here, was that they had expressed no interest. He didn't feel the need to train them in the gun, say the gun is there, but here's how it's used or not used, and so forth. I do think that she might be able to make a credible argument that, combined with their lack of interest, their advancing age to some extent, that he just decided that to conceal it as best he can, but leave it accessible to him should he need it to defend the home. That, again, it's negligence, but just not a conscious, reckless disregard for human life, which is a difficult thing. You and I were talking, Fred, before during one of the breaks, that we often liken that standard in the law to shooting a gun into a crowd. You don't intend to hit any particular person, but the recklessness is so extreme as to be a depraved indifference to human life. And I think she may be able at least to argue here that this is not the equivalent of shooting a loaded gun into a crowd.
But we know that the prosecution, because they've already told the jury, they're going to argue that he did precisely what the statute says you can't do. We can take a break, then come in. That's the prosecution calls its first witness, one of the children who was present in the Mevic home during the shooting.
we didn't want this to happen to our son or his son. And it was a simple thing to keep your guns locked up. I mean, it's common sense. And if another child's life is saved because they watched this on TV or read about it in the paper, then it wasn't for nothing.
Sean Caroline Sr. is on a crusade to keep kids safe from guns after his own child was killed by a .357 Magnum. Welcome back to Court TV's Open Court. I'm Fred Graham. 12-year-old Sean Caroline and his friend 14-year-old Louis Mevic Jr. were playing with Mevic's father's handgun, which they thought was unloaded. But Mevic apparently forgot to remove one last bullet. That bullet fired from the weapon and hit Caroline in the face, killing him instantly. The younger Mevic already did time in a juvenile facility, and now prosecutors are trying his father for felony culpable negligence for keeping the loaded handgun in easy reach of his son. Sean Caroline's parents are hoping for a conviction, but they are also lobbying for a law requiring gun locks. Currently, there's no such law in the state of Florida. At this point, we're going to go back in the courtroom for the prosecution's first witness, Blake Boyer. He's a 12-year-old. He was friends with the Mevics, and he was in the house on the day of the shooting.
Blake Boyer, right? And how old are you, Blake?
12 years old.
What part of the county do you live in?
Largo.
How long have you lived there?
All my life.
And who do you live with?
My mom, my dad, and 3 brothers.
3 brothers?
Yeah.
Are they younger or older than you?
Younger.
Okay. What school do you go to?
Largo Middle School.
And you just finished a grade, is that right?
Yes.
What grade did you just finish?
7th grade.
So next year you start 8th grade?
Yes.
Will that also be at Largo Middle School?
Yes.
What grades go to Largo Middle School?
6th, 7th, and 8th.
All right.